Good afternoon, everyone. Thank you for being there for the last session. First of all, I want to thank Dr. Malati and all the co-panelists. Especially if you have been following on Facebook, you know this trend is going on, 10-year challenge. So right now I'm just taking up a 20-year challenge, going 1999. And I was working with Dr. Malati in her lab. And now I'm here with you. It's a great honor, ma'am. Thank you so much. The topic for me was to talk on the Indian IP scenario related to GM technology and plant variety. And the statutes which are related to it in India, I'll stick only with India, is the Indian Patent Act 1970 and the Plant Variety Act 2001. Dr. Malati has already taken care of the Biological Diversity Act, which is interface between both of them. So that was our obligation under the CBD, and we have complied with it fully. So I'll not get into that. As for our obligation under the TRIPS, that's when our Indian Patent Act started getting amended. And the current act, after a series of several amendments, is the Patent Act 2005 that we are currently following. And when we talk of agribusiness, we need to think of both these statutes together. Now, what is getting protected under the Patent Act are the inventions, as Section 21J says that it has to be either a new product or a new process, which has to be capable of industrial application. Now, it has to be not obvious, and of course, it has to have an inventive step. Now, the definition of inventive step under Section 21JA of the Indian Patent Act says that it could be a technical advancement, or it could also have an economic advancement, economic significance. So it's really important that you're able to show either some technical improvement of your invention, of your product, of your process, or you can also show that there is some economic benefit coming out of it. Under the Plant Variety Act, now what is patentable is not the subject matter of the Plant Variety Act. What is registered is a variety, which is defined under Section 2ZA of the Plant Variety Act. It relates to a plant grouping, which is well defined in terms of expression of a characteristic, which is distinguished from all other plant groupings by way of that particular characteristic specifically, and which can be propagated as a unit. That is, that particular characteristic can go on to the next generation, and the variety and its propagating material would then get protection. Now, to be clear, what is not a variety? A single plant is not a variety. Now, if there's already a plant existing, it could have been a variety, but if you create a new one, it cannot be a single one. It has to be a grouping. A trait cannot be a variety. For example, the disease resistance trait. It could be the same trait, same characteristics in different varieties. So a single trait would become the subject matter of patents and not varieties. A chemical substance, for example, a DNA. Again, this could be considered to be within a plant, but it is not subject matter of plant variety protection. A plant breeding technology such as tissue culture. Now, all these, what are not varieties, are not my interpretation. They have been taken out from the explanatory note for the definition of plant variety or variety as adopted by UPA, the International Plant Variety Convention. And India follows it very closely, though we are not members, but we have been observers since the beginning. The Patent Act excludes certain things which are not to be considered as inventions. For example, those which are already naturally occurring. For those which is living or non-living, both are excluded under Section 3C. Section 3J is what everybody is talking about today after the Monsanto Supreme Court decision. And what it excludes, which also Dr. Malati explained in detail, was plants and animals in whole or part, as well as essentially biological processes. What are essentially biological processes is again to be found out. It's not just in India, it's outside as well, as my European co-panelists will agree that a lot of deliberations are going on as to what would consider essentially biological. Section 3H excludes method of agriculture or horticulture, that is mass production of plants or animals, if we say animal husbandry as well in agriculture. The reason I mention 3I here is the method of treatment of human beings or animals are excluded, but method of treatment of plants, which were earlier excluded, are now included. So you can patent method of treatment of plants. Section 3P, in a sense, prohibits traditional knowledge to be patented, though I feel that it is redundant in view of novelty reasoning. The exclusions under the Plant Variety Act are not many. They are basically related to public order, morality, environment, health. One can just note that unless the Plant Variety Authority notifies that these varieties can be registered, you cannot register anything else. Now, what all are protected under the Plant Variety Act are the new varieties. I'll not go into detail of these, all the different types, because we don't have so much of time, but these are the different types of varieties which you can protect under the Plant Variety Act. The rights which you get under the Patent Act for your product is to make use of, for sale, selling and importing, and for process is use of your process and the product obtained by the process. Now, all the rights related to the product above also apply to the product which come by the process patent. In case of plant varieties, the registered varieties under Section 28, you get the right to produce, sell, market, distribute, import, and export. Now, there's one special provision under the Plant Variety Act which applies to pending applications. It gives a provision, specific provision, a kind of a provisional protection for pending varieties where directions can be given against any third party who is performing any abusive acts against your varieties. Now, I mentioned this specifically because I'm going to refer to a Supreme Court case on this. The two Supreme Court cases, which I'm going to talk to you about, in which both of the cases I was involved in, so it's very easy for me to talk about it. The first case, Pioneer versus Kaveri. In this particular case, this is a case related to the plant variety. This was a maize plant variety name is 30V92. The Pioneer Overseas Corporations sued Kaveri Seeds Company Limited, saying that their pending application 30V92 is being abused by Kaveri because they are selling copies of it. Kaveri, in fact, went ahead and challenged the whole provision of Section 24(5), which provided for this provisional protection, and the Delhi Division Bench actually held that it is constitutionally not valid provision. But the Supreme Court stayed this particular order, and this provision currently is in force. It is still to be decided. It is not yet complete. We have to look forward to this case as to how provisional protection comes in picture. I also want to highlight this case for the fact that there are other matters before the Delhi High Court, including during infringement of a plant variety case, whether DNA sequences or DNA fingerprinting can be used to consider whether there's an infringement or not. So the DNA evidence is going to be critical, and this is what the Delhi High Court is also to be ruling on. Coming to the decided case by Supreme Court, Monsanto versus Nuzivedu Seed Limited, which came out on 8th of December 2019. This was a patent case. This was not a plant variety case. All the newspapers are reporting as the cotton plant case, but this was not. This was related to the genetic modified plant technologies, the GM technology, and the question was validity of Monsanto's patent. And the crux of the issue was Section 3J, whether the claims were covered under this section or not. Now, before we get into it, I'd like to just get into what the technology is all about. This is related to the invention wherein this particular bacteria, Bacillus thuringiensis, BT, was used and a gene of interest was extracted, Cry2AB gene in this case. It was made into a designer gene by making certain changes. Then certain steps like transformation and getting into the whole plant so that you get a plant which has this particular gene of interest was made. Then later, through plant breeding techniques, you can go ahead and mass produce this plant. Now, what was this designer gene? This designer gene was basically a part of three different products, three different nucleic acid sequences coming together, which leads to a fusion protein. Now, these particular genes will act in plants only when they are specified in which manner they do. The promoter will start the transformation, the transcription, and the plastid transit peptide, which is linked to this Cry2AB gene, will actually lead it to the place of interest where you want all the BT toxin to be coming together. And once the plant is made, the insect will eat the seed, eat the leaves, And the Bt protein, which is the toxin in the plastid peptide, will get into its gut lining and the insect will die. So the bollworm resistance will be achieved through this GM technology. Knowing the invention, now let's see what the claims were. There were 27 claims in total. Claims 1 to 24 related to a method of producing a transgenic plant, and claims 25 to 27 related to a nucleic acid sequence. Now, this particular sequence, which I just told you, was comprised of 3 parts. And for a gene to express, it has to have a machinery to express in a plant. Now, a bacterial gene to express in a plant, you have to have the machinery from other sources. So that was completely man-made. What happened before the Delhi High Court was, Monsanto filed a patent and trademark infringement suit stating for the patent 214436 and for the Bollgard BG2 trademark. And an interim order was passed by the single judge. The single judge prima facie held the validity of the patent and also the patent infringement, thereby saying that DNA construct is not a variety and it is not to be regulated by plant variety law, which the other party was contending. And then the problem happened when no interim injunction was granted. On top it all, the license agreement between the 2 parties, because this was Monsanto had already given a license and then terminated it. So this termination was also not considered correct. So neither Monsanto was happy, neither Nosy Vidu, so both the parties appealed, saying the license was not right, the patent validity was not right. And when it went to the bench, the division bench, now something important is to note here is the division bench did not analyze claims 1 to 24 at all. It only analyzed claims 25 onwards and held it to be essentially biological process. If you remember, the claim 25 was directed to a nucleic acid sequence. Anybody knows it's a product, but it was held as a process, essentially biological process, and considered to be excluded under section 3J. And all the claims 1 to 27 were all revoked, all invalidated, and the patent was revoked. Monsanto was directed to continue with the sub-licensing agreements, as well as to go before the Plant Variety Authority to go and register its particular technology that it had invented. Now, in this case, when Supreme Court heard it, and I have to tell you this, that it was a very detailed hearing. The court set aside the dates, and from September to November, all the 3 months, there was a day-to-day hearing from Tuesday to Thursday. And the decision also came very fast in January 2019 itself. The division bench the division bench order was revoked, and prima facie validity by the single judge was upheld by restoring of the patent. Now, the Supreme Court judges, they remanded it back to the single judge and asked that the whole case be decided after proper trial, cross-examination, and evidencing being taken on record. What people did notice that there was no observation on Section 3J. Now, some people thought that this was not right because the Supreme Court heard everything, all technicalities, the whole patent was argued, but did not rule on this matter. Not just rule, didn't even make an observation. And why was that? Well, I believe that that's because then the Supreme Court would have done what the division bench did without actually taking the whole procedure properly, giving a judgment summarily. So Supreme Court has followed the right jurisprudence by saying that it has to be done in a proper manner, especially when it's a technical and complex matter like a patent. So this is the case you have to look forward to. And we hope that the agri-biotech industry in India will be benefited after the final judgment is pronounced. With this, I thank you, and I can take any questions as directed by Dr. Malvi. Thank you.